Today we're talking with David McRae about the question of how and when employers should start having discussions with their employees on leaving on agreed terms. What's the main risk of an employer starting a discussion like this?
Starting a discussion about leaving their employment, the key risk to an employer is that the employee may react badly to such a discussion and resign and claim constructive dismissal.
And when is it safe for employers to start conversations like this?
There are two main safety nets for employers in respect of having what we would call privileged discussions with employees. The first one is to enter into without prejudice discussion with an employee where there is a dispute arising between employer and employee. Normally the content of such discussion would not be discoverable in future employment tribunal action. The other alternative is to enter into what's called protected conversations, pre-termination negotiations with an employee, and that's regulated by Section 11A of the Employment Rights Act, which allows employers to have protected conversations with an employee with a view to terminating their employment.
What exactly are pre-termination negotiations?
Pre-termination negotiations involve an employer making an approach to an employee in clearly defined terms with a view to that employee exiting their employment. In essence, the Employment Rights Act allows an employer to have full and frank dialogues subject to certain conditions with a view to making an offer to that employee to vacate their role.
And when will a conversation be privileged?
A conversation would normally be privileged, meaning that it couldn't be relied on in any subsequent unfair dismissal action at an employment tribunal where an employer has not conducted itself in an improper manner, using improper behaviour, examples of which may be issuing the employee with an ultimatum, i.e. accept this financial offer or I will proceed to dismiss you, or where there is clear evidence of the employer acting in a discriminatory manner.
So can an employer simply say to an employee that they want to speak to them without prejudice, and everything they say after that will be inadmissible in a court or tribunal?
Not necessarily, and the without prejudice rule is often misunderstood. In order to attract what we would term legal privilege, there must be a dispute capable of being settled.
Would a dispute exist if an employer was simply unhappy with an employee's performance, for example?
No, not necessarily, Laura. And a dispute would have to go further than that. For example, the employer may take corrective disciplinary action against an employee on grounds of performance or conduct. If the employee is not accepting of the outcome of such a process, they may enter into dispute, to may raise a grievance. Now, at that juncture, where there's a clear dispute capable of being settled between the parties, then an employer is within its rights to enter into discussions on a without prejudice basis, in the knowledge that such dialogue would not thereafter, or could not thereafter, be used against them in future proceedings.
How does a protected conversation differ from a without prejudice discussion?
The key difference, Laura, is that a protected conversation does not require a dispute in order to qualify for protection. Furthermore, under Section 11A of the Employment Rights Act, an employer must tick various boxes before qualifying for protection. For example, they must not conduct themselves in an improper manner towards the employee in the course of the negotiations, must give the employee at least 10 days to consider the offer. They must afford the employee, in accordance with best practice, the opportunity to meet to discuss the offer, accompanied with a companion, and they must not put undue pressure on the employee to accept the offer or issue ultimatums. The without prejudice rule carries no such criteria. There simply has to be a dispute capable of being settled, with both parties showing a willingness to enter into dialogue on a without prejudice, or to put it into common parlance, off the record discussion.
So what are the limits of the protection afforded by a protected conversation?
There are two key limitations, Laura. First of all, the protection afforded by the Employment Rights Act extends to ordinary unfair dismissal claims. It doesn't extend to discrimination claims that the employee may raise. By way of example, if the employee has committed an act of direct sex discrimination or race discrimination, the content of the pre-termination negotiations could still be used against the employer in the course of tribunals.
What would happen after an employer has had a response from an employee in respect of the protected discussion?
Well, after the employee's made their decision, there will be one or two outcomes. One, the employee will reject the offer and negotiations will continue or come to an end, or secondly, if the employee has accepted the offer in principle, the employer will make arrangements, normally via their solicitors, to prepare an appropriate settlement agreement which would ensure that any and all employment law claims that the employee may have against the employer are extinguished as a consequence of the financial arrangements agreed between the parties.
How risky is it to initiate a protected conversation?
Conversations in the context of employment are never entirely risk-free, but employers with proper advice can confidently go into protected conversations, pre-termination negotiations, if they're very clear about the parameters in which they must operate, and they're very clear about the extent to which protections will be afforded. So as long as the employer is following the legal parameters, then generally the dialogue between employer and employee in respect of pre-termination negotiation will be privileged and wouldn't be used against them in future litigation.
Thank you, David.
You're welcome.